Yesterday, Attorney General Jeff Sessions issued a decision that may result in the removal of thousands of immigrants who otherwise might have valid claims for relief under immigration law. This will include spouses of U.S. citizens, victims of violent crime who cooperated with the police, and certain juveniles who are afraid of violence in their home countries. And it reminds us that the immigration courts are not really independent courts. They are simply under the Attorney General and subject to whatever he says. This happened in a case called Castro-Tum, and what it addresses is something called administrative closure. Administrative closure is a system that the immigration courts have used for over 30 years to try to control their docket. It allows the immigration courts to temporarily close cases where, for example, somebody might have relief available in front of USCIS, or they're waiting for U visa numbers to become current, or they've got asylum claims pending in front of another agency. It allows the immigration courts to take these cases, close them temporarily, not dismiss them, but close them temporarily so that they're not pushing forward trying to remove people who may very well be eligible for green cards or other kinds of relief, but they're waiting on other agencies to catch up on their backlog. Now, it's been an accepted way of doing things for over 30 years. Most of the cases that have been administratively closed were done with the agreement of the government. The government said, this case is not one that we want to spend our priority resources on. We really want to spend our time on people who are criminals. That's the way that things worked until yesterday. Now it's all different. And I'm going to give you an example. Let me give you some examples of when this might be important. Let's say you've got a married couple. One spouse is a U.S. citizen and the other one is not. Person has no criminal record, no reason to think that they wouldn't be a good person to have in the United States, but originally entered without a visa, let's say, 15, 20 years ago. In order for that person to get permission to stay in the United States, he's got to get what's called a waiver of unlawful presence. Well, waivers of unlawful presence are gotten from USCIS, different part of the government. Immigration court can't issue those. USCIS can't do it while there's a removal case pending. So it was standard practice to administratively close those cases, let the person get their waiver, and then come back to court to process them. Another example is people who are victims of violent crime. They're often eligible for something that's called a U visa. That's for people who cooperate with the police so the police can catch people who committed violent offenses. They can apply for visas. Problem is, those are about a 4-year wait right now. And if that person's in immigration court, then it was common to close their case and wait and see if they got a U visa issued and then decide what to do. Well, that's the way it used to work. But you have to remember that the immigration courts are not independent courts. They're part of the Department of Justice, and they're headed by the Attorney General. And the Attorney General, in this case Jeff Sessions, he gets the final say on how the system works. And the way it works is that he can, at any time, refer a case to himself and then make a decision. In other words, the Board of Immigration Appeals makes a decision. He doesn't like it, so he refers the case to himself and writes his own decision. In fact, in Castro-Tum, he quoted a federal court saying that the BIA is, quote, a regulatory creature of the Attorney General, which I'm sure made the members of the Board of Immigration Appeals feel really special about getting up and going to work every day. But that's really the way it is. They don't have any residual authority in themselves. So, as a result of this decision, the Attorney General has issued instructions saying immigration courts no longer have the authority to administratively close cases, except under some very special, specific times when it's mentioned in statute. And that all of the cases that have been administratively closed in the past need to be brought back into court and prosecuted. In case you're wondering about how many cases we're talking about, at the end of the last fiscal year, it was more than 350,000. That's 350,000 cases in which an immigration judge had already ruled that the case should be administratively closed, and now they're going to be brought back in and prosecuted. You think we're busy now? You think the courts are backed up now? We're already seeing hearing dates set out to 2021, and that's before all of these things are added back in. So if you have any question about the effect this is going to have on the system, I think what we can expect is a great number of motions to reopen being filed, people losing their ability to seek provisional waivers, immigration courts getting even more backed up than they are now, and thousands of people receiving removal orders or taking voluntary departure when just a few years ago the government agreed that they should essentially be allowed to stay in the United States while their other cases were getting processed. That's just the world that we live in now. And it's just an example of how this administration has taken the position that they want to remove as many foreigners from the United States as possible under any means legally possible. That's the unifying theme. And everything they do is really aimed towards that. And this is no exception. You know, if there's ever been any confusion about it, that confusion is gone now. The only thing that really can be done in this day and time is for immigration attorneys, immigration advocates, anybody who cares about the immigration system or just cares about basic fairness and justice to step forward, support the immigrant communities, and work on bringing us a fair immigration system. You know, if you've been watching these videos for a little while, you know that usually wearing a shirt and a tie, and I do that so that, you know, I look like a lawyer when I'm putting out these videos. But today I actually just happened to be wearing this shirt when I got to work, and I found out about this decision and I decided that I was going to leave it on because I think that it really sums up the way we have to look at things now. If you can't read it from there, it's a quote from Dr. Martin Luther King. The time is always right to do what is right. The time to do something right is now. And if you're hearing this or watching this, I want you to know that we here at Lester Law will always stand with, support, and fight for the immigrant communities, even in the face of things like this decision and everything else that we're having to face lately. If we can help you, or if you have any questions about immigration law, or you just want to know how the whole system works, give us a call at area code 423-402-0608, or you can reach us online at www.lesterlaw.org. You can follow us on Facebook so you'll get these updates every week, whether they're good or bad, about what's going on in the world of immigration. Or go to our YouTube site where you can see our collection of videos that go back over a year at this point. So, until next time, stay safe, stay strong. We'll see you soon.